Good morning. My name is David Boudet, and I have the privilege to welcome you all to a new series that Miller Johnson is putting together in 2021. We have called it Workplace Wednesdays. Workplace Wednesdays is put in place because, in case you haven't noticed, we have a new president, and we have a president who is a Democrat. And the reason that is significant is because in the 30 years I've been doing this stuff, every time we move from a Republican to a Democrat or a Democrat to Republican in the White House, the laws, the rules that regulate what all of us do in business as it relates to human resources and labor change, and there are significant impacts. And so we decided at Miller Johnson to start a series that we call Workplace Wednesdays, where we're going to focus on those changes, those administrative, executive branch type changes and other legislative changes that we know will be coming over the next year. This series is going to start out with focus on labor, on unionization. And we're going to talk about what President Biden has done and what is likely to do and the impact it will have. As today's webinar will demonstrate, I believe, quite easily, is that the change that is coming is significant. In fact, in preparing today, I was thinking about how do I describe it in one word? And as I guess, like in all of your organizations, we've been working remotely, including the lawyers that we just started with our firm in early 2020. And so we introduced them by video in a firm meeting recently, and we asked them to describe what it was like to start during a pandemic, what it was like to work in our law firm as a brand new lawyer during the pandemic. And one of the lawyers, Sarah, she said, and she looked in the screen and she said, help, just please bring help. So I'm going to leave you with that is probably the best way to describe what we're about to go through over these, a little bit today, but over the next 8 weeks or so during these workplace webinars. So with President Joe Biden, can we predict as to what he is going to do as it relates to organized labor and unionization? And the answer is yes. Joe Biden has said this repeatedly: I will be the most pro-union president you have ever seen. And we can just look at his own words. During the campaign, he put out what was called the Biden Plan for Strengthening Workers' Organizing, Collective Bargaining, and Unions. And if you go up on the web and read this, it will tell you what his thoughts are in plain English. And we're going to highlight just some of these things today to give you a flavor about the types of things that we're going to need to discuss over the next 8 to 10 weeks. But I want to share some of the premise of the Biden plan. The Biden plan's premise is that there is an us and a them. That is, there's a worker and there's management, and there's this inherent conflict. In the plan itself, he uses pretty strong language, and I would consider to be divisive language, that suggests what the relationship is between the organization and the worker. For example, he writes, employers steal. That's not, again, words matter. Not employers steal about $15 billion a year from working people just by paying workers less than the minimum wage. On top of that, workers experience huge losses in salary caused by other forms of wage theft. And then he says, at the same time, these companies are raking in billions of dollars in profits and paying CEOs tens and hundreds of millions of dollars. Again, that is said to create a reaction and create a certain description and narrative of environment that creates the abilities for unions to get in. We're going to talk for 8 to 10 weeks about what's going on here, but all of us on this phone call who have been involved in human resources and running organizations know that the reason that our organizations do not have unions or do not have organized labor is because we don't steal from our employees. We don't engage in theft from them. We instead empower them. We engage them. We provide a workplace that respects them. We respect their dignity as individuals. And we take human resources seriously. I think what we're going to learn over the next 8 to 10 weeks is that all organizations need to elevate their human resources. We need to find ways to treat our folks even better and be even more aware of those things, which we can look at as, gosh darn it, why are we doing this? Or we can look at this as an opportunity for us to improve as organizations, as opposed to maybe a burden we'd rather not have to carry. But, so what does the Biden plan say? According to the Biden plan, again, I'm giving you a 10,000-foot view of this plan. This is what he says he will do as president. And these are quotes. He will check the abuse of corporate power over labor and hold corporate executives personally, again, the word personally accountable. So he's going to hold you and me individually, not our organizations, us. He's going to encourage and incentivize unionization and collective bargaining agreement. Folks, that's the President of the United States saying that. I'll talk about that in a little bit. Fourth, he's going to ban right-to-work laws, as Michigan is, right? We're a right-to-work state. He's going to ban that. The federal government's going to come in and tell the states that they can't do that. That's what Biden wants to do, President Biden. And he's going to strongly support the PRO Act. And what is the PRO Act? The PRO Act, for all of us who are old enough to remember the Employee Free Choice Act under President Obama, is the Employee Free Choice Act on steroids. What it is legislation to help encourage and incentivize unionization in the United States of America. And the reason we highlight this is because the PRO Act isn't just some idea that's been written in some halls of some labor union halls. No, the PRO Act is a piece of legislation that passed the U.S. Congress. The Congress has passed this legislation. The only thing between it and becoming law is the Senate and the signature from President Biden. But again, over the weeks ahead, we will talk about this in greater detail. So what does the Biden plan say about checking the corporate power? Well, this is what he said. He talks about how he supports the PRO Act, how he supports instituting financial penalties. And it's interesting what he says, though. It's not just stiffer penalties on corporations, but he says we're going to hold company executives personally liable. He understands what he's doing when he says that. And the federal government say now if we have an unfair labor practice, we don't respond to requests for information. We cross these lines that wiggle all over under the NLRB based on what we can and can't do, that any two lawyers can never agree on exactly where the standard is. But we're going to make you individually liable as the executive in the organization if these things occur. But if personal liability isn't enough, that is dollars out of your pocket for a fine, he wants to make clear that he has your attention, because we're going to have criminal liability for any intentional interference with your employees' right to join unions. So what does the PRO Act itself propose? This piece of legislation that Congress passed it. What does it say? And again, I could spend lots of time. It says a lot more than this. I'm just giving you highlights. But it says, look, if we have a violation, an employee has been violated, employee rights have been violated under the National Labor Relations Act, he's been discharged, or has other serious economic harms been in the employee, what can he get? Well, first, it says he can get back pay. But it says without any reduction for interim earnings. So that means now when someone may be discharged, and the NLRB may say it's for an unlawful reason, the employee gets the lost back pay plus what he or she earned in the interim, no longer. In addition to that, not only are we going to have back pay, we're going to have front pay. Not only are we just going to have front pay, we're going to have consequential damages. And not only are we going to have consequential damages, we're going to have liquidated damages. So when he said we're going to penalize people, these are just some of the things, and there's much more. What does the Biden plan state about encouraging unionization? He says, again, too many employers pretend to bargain with unions, that is, with no intent. So now he says he's going to give the NLRB the power to force a union who was found to have bargained in bad faith back to the negotiating table as called for in the PRO Act. And there's going to be financial penalties for that. That's what he says. And you require companies to pay a penalty to making workers whole. So in addition to paying the impacted employees, we have penalty provisions in there if the employer is found to engage in bad faith bargaining. And he says the federal government should not only defend workers' right to bargain collectively, but also to encourage. And I highlight the word encourage, and I'm going to pause here for a moment and talk about this because it's something I think we need to think about, regardless of where you sit on the political spectrum, regardless of how you see President Biden or anyone else in our government. Under the First Amendment of our Constitution, we have the freedom to engage in association. That is, we have the right to join the Democratic Party, the Republican Party, the right to be Catholic, the right to be atheist, the right to be Jewish, the right to do what we want, to join the Eagles Club, to join the Knights of Columbus, to join whatever it is that we want to join. But no one can force us to do those things because we have the freedom to associate. And the federal government can't use its power to make David Boudet want to join any particular organization or you. And historically in our country, we've butted up against this freedom to associate in unions. When unions first evolved and developed in our country, there was a time when we had true closed shops. That is, the closed shops required that in order to work at a particular unionized employer, the employee had to join the union and pay dues. And joining a union, for those of you who haven't joined, does oftentimes require stating an oath. It does require adhering to a constitution. And because unions are political creatures, that's been recognized time and time again, that you're being asked to subscribe and support a particular political perspective. The Supreme Court has stepped in and said, no, you can't do that. The legislation changed under the Taft-Hartley Act. And what happened then instead is that in the United States of America, where it is today, is employees in non-right to work states can be forced to pay union dues to keep their jobs, but only those portions of the dues that the union uses to represent the employee. That is, the political portion of the dues you cannot compel an employee to make, even in non-right to work states. And right to work states, as we know, you can't force an employee to pay dues, period. So when the federal government starts putting in policies that says we're going to encourage unionization and we're going to encourage membership, we are now asking the federal government to use its influence, its power, its agencies to force associations. What will happen is there will be litigation over this. How it turns out, I have no idea, but I've just said for you the arguments that will come. Whether these are from organizations like the Association Building and Contractors, whether this is from the Mackinac Center, whether it's from the Heritage Center, whether it's from other think tanks in the United States, there will be litigation, the chamber or otherwise. This will come up to the extent that President Biden continues to use this type of language, engage in this type of behavior. What does Biden say about banning right to work laws? I just briefly highlighted that. What does he really say about it? Well, he says currently more than half of the states in place have these right to work clauses, which in fact deprive workers of their rights. Again, you can see his perspective. These laws exist only to deprive unions of financial support they need. And again, that's true. In the state of Michigan, it does lower the amount of financial support. I would use a different word than deprive, but it certainly does reduce the amount of financial support for unions if they are not giving benefits to their membership or to the employees. They choose and they exercise the rights to not pay dues. But the federal government under President Biden wants to make that not possible. As he said, he will repeal the Taft-Hartley provisions that allow states to impose right to work. So in the state of Michigan, there is going to then be a clash between the preemption of the federal law if that occurs and the state laws. And again, there will be litigation over that issue as well if that moves forward. So again, pretty significant sea changes. What is the PRO Act? The last thing about the PRO Act that I want to highlight here, and I think this is significant just to put in your mind, I think of a 10,000-foot view, is under the National Labor Relations Act. Anyone who's been involved in that knows in order for someone to bring a claim, all of those things are exclusively handled by the National Labor Relations Board. The federal government, through the National Labor Relations Board, prosecutes those claims. They're done through an agency, the NLRB, although there was review at the Court of Appeals level in federal court. But now, for the first time, someone has proposed if the PRO Act would to be enacted the way it currently is passed through the Congress, you would have a private cause of action. That means individual private law firms can then bring claims on behalf of employees and they go to federal court. And in the legislation, it makes clear the types of damages they can seek. They can seek back pay, they can seek front pay, consequential damages, liquidated damages, punitive damages, and for those of us who are lawyers, this is significant, and attorney's fees. So even if someone's lost $5,000 in overtime pay, so to speak, you say, why would a lawyer take a claim for $5,000? Well, if the lawyer can get liquidated damages, punitive damages, plus get his or her attorney's fees paid in full, then of course a lawyer will bring that claim. So this piece of legislation, which some people may say, well, that's just like Title VII, where you can bring claims that the EEOC doesn't bring forth and any other civil rights law. What's the difference? Well, the difference will these claims will then become much more significant. And those of us who practice in this area tells you the boundary lines and what is permissible and impermissible shift with the political winds, and it's difficult to determine what is and is not a violation of the National Labor Relations Act in many occasions. And so now the price of making those mistakes or not being up to speed with the political winds becomes significant. And now those things can be prosecuted by individuals, and that will be a significant sea change. The last thing that I'm going to talk about is this amazing concept that President Biden has come up with. He wants to take and make what he calls it the labor group, and he wants to make it a cabinet level working group. And by cabinet level, I want to make sure that we understand what we're talking about. We're talking about the cabinet of the President of the United States of America. There's 15 individuals that are part of that, 15 positions, I should say. And they're the highest ranking officials in the federal government. They include things such as the Secretary of State, the Secretary of Treasury, the Secretary of Defense, the Attorney General, those types of people. President Biden wants to promote this cabinet level working group to, again, this is a quote, solely focus on promoting union organizing and collective bargaining. I don't think I need to say more than that. And if you think how important this is to the president, as we all know, President Biden is not unusual. That is, presidents speak in their first 100 days. What are we going to do? What are the big things we're going to do in our first 100 days to make change consistent with my beliefs as the president of your country? Joe Biden says in the first 100 days of the administration, the working group will deliver a plan to dramatically increase union density and address economic inequality. To dramatically increase union density, to encourage, to promote, to do what it can to make sure more workplaces are unionized. That's what President Biden has said repeatedly, and I think it's crystal clear what is going to happen. Now, from here, we're going to transition to my good friend and partner, Nate Planiga, who's going to talk a little about what the president has already done. But again, I think I'm going to hearken back to what I started this with, folks, and I'm going to leave with one singular word: help.
Well, that was cheerful. I expect that everyone on this call is now desperately in need of some good news. And I'm sorry to say that you're not going to find it here. David obviously has talked about the administration's labor goals. And those goals are significant. And I do think that employers are going to need some help. But at least some of them are a ways off. And if we're lucky, it's possible that we'll avoid some of the worst of it altogether. But some changes have already happened. And some changes are clearly on the immediate horizon And that's what I'm going to talk about here briefly, starting with the General Counsel for the National Labor Relations Board. And the General Counsel is a politically appointed position. The individual serves for 4-year terms. And that person ultimately oversees all of the NLRB's regional offices all over the country. And that means that the General Counsel has tremendous influence over how the regions conduct their business, including, for example, whether they dismiss charges against employers or whether they prosecute charges against employers, and including how they conduct union elections. And the General Counsel also has tremendous influence over the law and really the ability to shape the law, because the General Counsel's office issues guidance and interpretations regarding issues that haven't been resolved in case law or questions that are left unanswered by case law. So the General Counsel essentially steers the ship of federal labor policy. And on President Biden's inauguration day, the General Counsel was Peter Robb, who had 10 months left on his term. And on day one, in fact, in hour one, more specifically, 23 minutes after assuming the presidency, President Biden asked for Peter Robb's resignation, which I think is about as clear a signal of the importance of federal labor policy to President Biden and to his administration as you could ask for. And Peter Robb declined. He sent a letter to the White House that any action to remove him would undermine Congress's intent that the office of the General Counsel be an independent office, and that the General Counsel not be worried about whether he or she was pleasing whoever happened to be in the White House, or that if he or she displeased the president, that their job would be on the line, that independence was necessary for the appropriate, neutral, unbiased administration of federal labor law. Well, that appeal, that letter from Peter Robb didn't work because on day 2 of his presidency, President Biden terminated Peter Robb. And that's the first time in history that a president has fired the NLRB's sitting General Counsel. And as David said, administrations have typically very different views of labor law. And in general, and again, regardless of anybody on this call's, individual political views, in general, Democratic White Houses favor organized labor, and Republican White Houses favor business. And that acts out in ways that we're going to talk about in a second. But when a president assumes office, at least historically, the president inherits a General Counsel and allows the General Counsel to serve out his or her term. And so, this is the first time we've ever seen action at this level. It was, in the true sense of the word, unprecedented. And when President Biden terminated General Counsel Peter Robb, Peter Robb's number 2 stepped into the vacuum, Alice Stock, and she lasted less than 24 hours before President Biden terminated her on day 3. President Biden then took an eternity, 3 whole days, to nominate a new acting General Counsel, whose name also happens to be Peter, but these are 2 very, very different Peters, at least in terms of their fundamental outlooks. And Peter Sung-Or not only has a very different perspective in terms of priorities and I think sort of fundamental agreement with the direction that the White House has announced here, But I think given the way in which he ascended to the office, it's going to be unmistakable to him that he serves at the will of the president. In other words, that his job is tied to whether he effectively pursues and promotes President Biden's labor agenda. And obviously, President Biden has been very public about that, as you just heard from David. And Mr. Orr wasted no time at all. I mean, in the first week of his new position, he announced the revocation of 10 general counsel memos that had been issued by his predecessor, and promised a number of new general counsel guidance and memoranda in the very near future. And I don't expect most of them to come as welcome news to employers. I think that the general counsel's office is going to swing the pendulum pretty significantly, and I think it's going to swing almost immediately. And so that's the general counsel's office. Now we'll talk just for a second about the more well-known entity, which is the National Labor Relations Board itself. And the National Labor Relations Board is 5 politically appointed members in Washington, D.C., at least when all of the seats are filled. Right now, they're not. And when the seats are filled, it's either 3 Republicans and 2 Democrats, or 3 Democrats and 2 Republicans, depending on which party controls the White House. And so the control of the White House, the office of the presidency, makes a huge difference in the board's majority. And the board's majority makes a huge difference in the board's actions and decision-making. And the NLRB is the true power center of federal labor law because it makes the law. It makes law in 2 ways. It issues decisions, which are the same thing as case law, the same thing as federal courts in terms of their significance and their impact, and by issuing rules. And we've seen increasingly the board try to make law through rulemaking. But there is one significant difference from the federal court system, because the federal court system, regardless of the political views of the appointees, tends to respect precedent above virtually all else. So a panel of a federal court of appeals that's reviewing a decision may disagree with that decision, may wish that it could go in a different direction, but if that decision is based on an issue that has been decided already, 9 times out of 10, the court will follow precedent. And the board is the opposite. The National Labor Relations Board vacillates wildly depending on who has the majority, which makes it very difficult for employers to figure out, which end is up, because the law changes, procedure changes, and the board's decisions can and often do tilt the playing field. And tilt might be too soft a word. So just by way of example, in the next year or year and a half, here are some questions that have been subject to waxing and waning over the last several years that I think are about to change again. So do employees have a right to use employer property, such as your email system, to criticize their supervisor, to criticize management, to criticize the company itself? Or can they use your property to organize a union? Well, right now the answer is no. I will bet anyone on this call $100 that the answer will be yes the next time that issue comes before a board that is a majority of whom are Biden nominees. Do employees have a right to a representative? let's say that you've got an employee that you believe is engaged in misconduct out on the plant floor, and you want to talk to them about it, figure out their version of events in order to make an appropriate decision. Do they have a right to call a halt to that process until they can get somebody in to represent them for purposes of your conversation with them? Right now, the answer is no. My guess is that we're going to see the possibility that also changes. Can employees have a right to behave unprofessionally, to disrespect their supervisor to his or her face, to swear at leadership, to issue threats on social media, or whatever the case may be? I think a lot of folks on this call remember some of the cases that came out of the Obama administration's board, where employees who engaged in absolutely abhorrent behavior. I think any reasonable person would say that their behavior was 100% no-brainer terminable, were restored to their jobs by virtue of the fact that they had been engaging in protected concerted activity at the time that they got upset enough to do whatever it was that they did. Some of that conduct was extraordinary. The board has, in the last several years, restored the notion of civility to the workplace, restored employers' ability to demand that employees treat one another with respect, has restored the idea that employers can require a measure of professionalism. And I think those changes are on the chopping block. And those are just examples. There are, we will be talking in the next several weeks, and today's webinar is really just designed as an overview or an introduction. In the next several weeks, we'll be talking about a lot of these examples in depth, because I think one thing that employers need to understand and know is what cases are likely to be overruled and what changes in the law are likely coming, because I think that will help you, of course, decide how and whether to plan in anticipation, how to plan to address it or to contain it. Decisions from the NLRB can and often do change procedure. How much control does the union have over the groups it wants to organize? Many of you are familiar with the term micro unit, and the idea that unions can, it's a form of gerrymandering, really, where you can, sort of pick and choose who you'd like to represent in order to maximize your chance of success, in order to maximize your support. And in general, the smaller a group, the easier it is for a union to organize it. And the larger a group, the more difficult it is for a union to organize it. And so the law in this area has gone back and forth in terms of how much control a union has to dictate, a group that is sort of a carve out of a larger group. Can a union organize virtually? How much time does an employer have to respond to notice that a union is engaging in organizing activity, and what rights and defenses does it have? And those are issues we're going to talk about again in more depth, but they make a huge difference in an employer's ability to effectively communicate to its employees about whether they've got the full picture, whether there's some additional considerations that they, might want to evaluate before they go to make their decision in the voting box. And of course, it is the employee's decision. Employees have rights either way, but the employer has the right of free speech, the right to educate, the right to communicate, and the amount of time and the guardrails around that free speech make a profound difference in the employer's effectiveness. And then just a couple of examples about tilting the field. Can the board openly encourage union organizing? And I would have said no to that, in the sense that the board is supposed to be the federal agency that's responsible for administering the Act, the National Labor Relations Act. And the National Labor Relations Act says that employees have, the right to organize, or the right not to organize. I mean, both of those pieces are in Section 7, which is the heart of the NLRA. But we've already seen some of the words from President Biden's campaign where the word encourage is prominent. And we've seen under past administrations, the board go quite far in abandoning neutrality. So if you look at the bottom right of this slide, a few years back, the Obama board posted a Google ad that said, find info on how to start a union, get the process and more on our site. And, the site was nlrb.gov, which was at the time sort of astonishing, soliciting organizing. Can the board deter employers from defending themselves? And I think the answer to that is absolutely. It's very difficult for employers who, let's say, have a charge that they think is without merit. It's very difficult to make the decision that you're going to litigate over that charge for the next 3 years, which is what is likely to happen if you think that it's unlikely that the board will view things your way, or that the board will view things even in a neutral way, and that you'll have to appeal the decision of the board all the way to a federal circuit court in order to get an audience that you think will address your case in an unbiased fashion. If that's the path, if the path is that much time, that much energy, that much money, the temptation to just capitulate, even where you think that your action was appropriate, is a pretty significant one. And that's going to become complicated, as you'll see in the next weeks, by the additional teeth that are being proposed in terms of penalties for violating the National Labor Relations Act. So I think employers are going to be caught in a bit of a catch-22. And of course, can the board rewrite your employee handbook? That's one of the most prominent ways in which non-union employers, union and non-union employers are affected by all of this, but that's one of the most prominent ways in which non-union employers have been affected over the last several years by a National Labor Relations Board that has increasingly tried to expand its reach into the non-union realm, and has done so by focusing on employer policies and by dictating what types of policies employers can or cannot maintain and apply. So I think we're going to see a lot of changes in all of these areas, and I think we're going to see them because, again, President Biden has made it fairly clear who he thinks, or at least what he thinks, is the most important criteria for eligibility to serve on the NLRB. And he's already named Lauren McFerrin the chairperson. No surprise there. But in terms of timing, in terms of when the NLRB will make this switch from 2-3 to 3-2, President Biden can nominate one replacement now because there is an existing vacancy on the board. And then President Biden can nominate another replacement in August when Member Emanuel's term expires. And, whether or not he'll act immediately, I'm not sure. I mean, typically presidents take a while. I mean, there can be vacancies after a new president assumes the White House for up to a year and a half. But given how fast President Biden moved with the General Counsel, I don't expect him to waste much time. I think it's possible that, by early fall, we'll have Senate confirmation proceedings for the final piece in the majority puzzle, and we'll have a board that I expect is going to be fairly uniform in its thinking and probably fairly activist in its outlook. So that's the NLRB. And if everyone is still here, and if you have Adderall to put in your coffee, you might want to do that. I'm not going to focus too much on the PRO Act. David mentioned it. We're going to go into it in significant detail in the next two sessions. I think that the issue really is that you've got to hear it to believe it. It is different in terms of scope and content than anything we have seen before. David's been doing this for 30 years. I've been doing it for 23 years. We've never seen anything even proposed that goes as far as the PRO Act. And, essentially I would describe it as union's Christmas wish list. And I mean everything on that list, everything that you need, everything that you want, everything you would really love, which is sort of your stretch ask of your parents, certainly what they want to read, and I'm sure there's something in there that they can wear. It is a fundamental change in federal labor policy, and it is, unabashedly designed to do exactly what the administration has suggested it wants to do, which is to encourage union organizing. When President Biden announced this cabinet level group, he said he wants to dramatically increase union density. And the PRO Act, which you will hear about if you're not experiencing post-traumatic stress disorder next time, would absolutely serve that purpose. All right, last slide. What else can a president do? Plenty. Executive orders are not a small piece of the picture either. We've seen presidents in the last several years on both sides, from both parties, increasingly rely on executive orders. And in labor law space, that can affect anybody who's a federal employee. It can affect employers who have federal contracts. That notice posting to the right there on the slide is just one example. Something that an executive order could require every covered employer to put up, making sure that employees know about their right to organize. And of course, the president can exert political pressure. If it doesn't like what, let's say, a large company is doing, maybe Walmart is, opposing a union organizing drive, or Amazon. There's a reason why it's the bully pulpit. The president can, call out a corporation in an environment where, public relations and, corporate citizenship are increasingly important, and where an employer's brand is its currency. The president can, I think, put some significant pressure on employers to at least relax their efforts to oppose unionization. And at the end of the day, we've certainly seen in recent years that presidents can take their message directly to the public. Social media is very effective for that purpose. And there's no reason why President Biden couldn't, for example, make clear that, at least from his perspective, employees do better with a union than without one, that they make more money, that they have better benefits, that they ought to be interested in this, that they ought to pursue it. If they want to pursue it, how they can pursue it. So what can a president do? As it turns out, a lot. And we wanted to keep each of the individual sessions in this series brief and manageable. So we'll end there for today. This was to set the foundation for what is to come. And the next two sessions are going to get more into what the proposed changes would do to turbocharge union organizing. That's it. And we will look forward to continuing to march down this path. And obviously, our goal is not just to educate you, but to provide you with some of our ideas about what you can do to prepare for all of this. Thank you for attending. We appreciate your time. Have a great day.